Hello friends, Namaskaram. Today we will discuss section 147 of NI Act. Not in theoretical perspective but in practical perspective. Basically section 147 of NI Act is concerned with compounding of offence. Do you know when an offence is compounded? In that scenario, the court may declare you from the offences to be acquitted even though there is no trial of you, but on the basis of compounding, the said proceedings could be done. Section 147 of NI Act inter alia incorporate provisions regarding the offences to be compoundable. It says that notwithstanding anything contained in the CrPC, which is now BNSS, every offence punishable under this Act shall be compoundable. But basically it is a theoretical perspective. In practical way it is not easier to have the compounding of offences, so I will discuss the practical perspective and how to deal with. For this I request all of you to maintain a notebook with pen or pencil and update your information accordingly. There are multiple cases wherein the accused is harassed by the concerned complainant on point of compromise. The first defense point is that whenever we are having a case of section 138 of NI Act and inter alia we fail to make payment within 15 days from date of service of notice, in that scenario if the concerned complaint is filed and we are summoned through court, in that scenario within 15 days from date of service summon we may deposit the amount to the concerned court and could claim discharge from the liability. So this is one of the most important point of discharge, wherein the concerned complainant is not willing but the accused is willing to settle the case. Because as far as my knowledge is concerned, whenever a case under section 138 of NI Act is filed, the concerned complainant inter alia set up a theory. The usual theory is that the concerned accused borrowed a certain sum, and to pay the amount he inter alia executed a cheque with assurance that the payment of cheque amount will be received to the concerned complainant on deposit. When the cheque was deposited, it got dishonored. Finally, notice was given, and in the meanwhile, complaint was filed as per the protocol of section 142 of NI Act. So, in that scenario, as I submitted earlier, if the amount is not deposited earlier and you really want to deposit the amount, and apart from that, you want that the matter is to be disposed of immediately, then within 15 days from date of service of summon you may deposit the amount of cheque before the competent court so that you could claim discharge from liabilities and proceeding could be dropped, and the view settled by Honorable Supreme Court as well. So we are going to categorize it as point number 1 of defense. Apart from that, there are circumstances wherein you had appeared, but ultimately at the earlier stage you want to settle this court, but the said proceedings are not conducted within 15 days from date of service of summon due to lack of knowledge or information. Even in that scenario you may do so without any consent of complainant. The same is permissible as per verdict of Honorable Supreme Court. For this you have to deposit the cheque amount, and court may direct you to deposit the certain compensations with penalties, and whenever it is deposited, in that scenario you would be declared acquitted from the charges, and apart from that the proceedings would be dismissed and would be disposed of accordingly. So this is defense point number 2, to get acquittal from the case if the concerned complainant is not willing and ultimately he is going to cause negative interference in the proceeding of compromise. The third point is that there might be a compromise between you and the concerned complainant. In that scenario, if you are going for a compromise, court may direct that 10% of cheque amount is to be deposited as per guidelines of Honorable Supreme Court. If you want to bypass the same, it is advised to have an agreement outside the court. In the agreement, you may narrate that the entire amount is to be deposited to the concerned complainant, and that's why he promised to withdraw the complaint. The said agreement would be binding on the complainant as per section 15 and section 121 of Bharatiya Sakshya Adhiniyam. It is also advised to have this document properly notarized with the help of notary public, which is frequently available in the court premises, and after that the concerned complainant will file the application to withdraw the case. In that scenario, simply he has to pay ₹1. In this way, we may save lakhs of or thousands of rupees of the concerned client. Apart from that, if you are convicted, appeal is pending before court of appeal. In that scenario, a compromise occurred. You may request the concerned court to send the matter to Lok Adalat. And apart from that, when there is a Lok Adalat, you may request that the amount of 10% usually awarded to be deposited as per guidelines of Honorable Supreme Court is to be exempted. Looking to the financial conditions of the concerned accused, if it is not allowed in that scenario, compromise would fail, and finally the purpose of section 147 of NI Act would be frustrated, and apart from that the purpose of Lok Adalat proceeding would be frustrated. So in 99% cases the order is made in favor of accused, and in this way we may save lakhs or thousands of rupees of concerned accused while having the proper proceeding of compromise. In case the concerned complainant fails to cooperate, in that scenario even the accused could insist to send the matter to the concerned Lok Adalat. As per settled legal position, the proceeding under section 138 of NI Act is basically a quasi-criminal, quasi-civil proceeding. So if the concerned accused is willing to deposit the amount and ultimately it is found that the concerned complainant is going to extort the concerned accused, in that scenario the proceedings in nature of Lok Adalat could be taken into consideration and the matter could be sent to the concerned Lok Adalat so that compromise could be settled. So this is also one of the most important way to settle the case as per section 147 of NI Act. So now we are totally clear on the subject and also on practical application of section 147 of NI Act. See you in the next video. Till then, Jai Hind, Jai Bharat.